Good afternoon. My name is Stacy Stanislaw. I'm the Director of Communications here at the libraries, and I'm so excited to celebrate Open Access Week with you all, especially with today's webinar featuring our librarians, Hannah Berdyman, who's our Discovery Librarian, and Matt Sherman, our Digital Curation Librarian. So first, for those of you who may not be too familiar with Open Access Week, it's this really exciting international event that promotes open access to research. It offers an opportunity for the academic and the research community to learn about the benefits of open access, to understand more about it, and hopefully, get excited about publishing their research as open access. Over the last few years, the libraries has been doing a lot more around open access, both to educate the Drexel community about what is open access, and how to take advantage of open access publishing, but also to negotiate different article processing charge agreements that make it easier for members of the Drexel community to publish their research in open access journals, either for free or at a discounted rate. So I'm going to drop a link in chat to some information about our different APC agreements. So if you want to learn more about that, you can. So that's a really exciting thing we've been doing for a while now. And Hannah can certainly answer questions at the end. She's been taking the lead on that for us. But today, our session is going to focus on open access and your copyright. Hannah and Matt are going to first give an overview of copyright and Drexel's IP policy, and then they're going to delve into open access publishing at a more general level. And then we're going to end today with a discussion on copyright and AI. So I expect that'll be pretty interesting and lively. It's a pretty hot topic right now. So with that, a quick note, please stay muted throughout the session. If you have questions and you're just, got to get them off your chest, you can type them in chat and we'll read them out loud at the end of the session. Otherwise, just hold your questions and we'll have time at the end. I think that's it for me. So now over to Hannah and Matt. Thank you both.
Hello all, I'm Matt Sherman. Allow my co-host to introduce herself real quick.
Hi, I'm Hannah Berdyman.
All right, and we're librarians talking today to you about, as Stacy noted, open access, copyright, and AI. And part of the reason we're giving this talk for Open Access Week is the theme, because Open Access Week is a bit of an international event every year. And this year's theme is based around the question of who owns knowledge and scholarship. So we thought this would be a great opportunity to just help our community better understand copyright and themselves as copyright owners, because all of you guys create things, you own the copyright when you create them. And we'll get a little bit more into the details of that, at least at a high level, how that works. And so we wanted to help you better understand that and think through your ability to publish going forward that way. And so before we really get going, though, we do want to note both Hannah and myself are librarians. We are not lawyers. As such, this is not legal advice. Do not take this as legal advice. We're just professionals who work with this a lot, and so we're pretty well read up. We have a good understanding of things, and we want to help you to understand better. But if you have legal issues or concerns related to copyright, talk to a legal professional. And we're not liable for anything you do with this information, but hopefully this at least makes you a more well-rounded scholar. So now that that's out of the way, when we're talking about copyright is a form of intellectual property. And when we're thinking about intellectual property, at least in the context of US law, there's sort of three categories we tend to think about: copyright, patent, and trademark. Copyright's really focused a lot on sort of protecting a creator's expression of their ideas, whereas patent has much more focus on the protection of an idea behind in a form of innovation. And trademark's a little bit of the odd duck there, where trademark in many ways is almost a consumer protection form of intellectual property by helping to properly identify certain groups and organizations and products so that people know that they're going to the right thing to get what they're looking for. We're not really going to talk much more about patent and trademark in this talk, though patent will make a brief cameo halfway through. But we just wanted to make sure you had an understanding of intellectual property before we really dive more into copyright. So with copyright, what exactly is it as a piece of intellectual property law? So it's a type of intellectual property law that really protects the works, original works specifically of creators and authors that are put in a fixed and tangible form of an expression. And that term fixed form is going to come back throughout. It's a pretty important concept in copyright. But what copyright then lets you do legally is it gives you protections and sort of power as a creator over your works so that you can allow or prohibit your original works to be used in certain ways. Now, of course, when we're talking about copyright, there are things that falls under copyright and there are things aren't. Under US law, there are very specific categories of what is covered under copyright. And this list here is actually pulled right out of sort of what's the laws on the books. So literary works, musical works, dramatic works, pantomime, choreograph, pictorial, graphic, sculptural, motion pictures and audiovisual, sound recordings, and architectural works. Anything that's going to be in copyright in US law is going to fall under one of these categories. And they can be a little bit more expansive than you might think at first blush, because software can be copyrighted, and that actually falls under literary works. So there's a little more flex in these categories than you might think. But if a work doesn't fall into one of these categories, even with a more expanded definition, then it's not going to be protected by copyright, but it might be protected by some other form of intellectual property right. So say you have work within one of these categories. All right, so what do you actually get out of copyright? And copyright is really a bundle of a couple of specific rights that you as a creator have. You have the exclusive right to determine to either permit or deny somebody to reproduce your work, distribute your work, display your work publicly, perform your work, or make a derivative of the work based off of your original. And so within the context of those rights, you as the creator can then tell somebody, you can either give them permission to, say you wrote a paper, you can give them permission to make additional copies of it, hand it out or distribute it through a publication, or you can tell somebody, no, you can't display that publicly. As the creator, you have that. You have either of those options. When you're providing permission, it sort of falls into two rough categories of either you sort of waive your right and you just choose not to exercise it, or you enter into some kind of contractual agreement with the person using your work to provide them a license to do one or all of these things. It's not an all or nothing thing with copyright. You can choose to permit some rights to a person, but not other rights. So as long as you decide which ones with this, there's options. And this is also where Creative Commons comes into play, where you can decide when you create something that, oh, I want to just in perpetuity allow people to have these certain rights, but with these stipulations. And different types of Creative Commons licenses will give when you apply that to that, we'll just let people know, all right, I have the right to reproduce it in this way, but not for commercial use, or things like that. Also, technically, there is a sixth right in here that's not on this list because it only applies to sound recordings, and that is the right to transmit them. So not going to come up for most folks, but it's good to know that it's there. So obviously with these rights, there's the question of, well, then how do I protect them? And in US copyright law, at this point, the way that you gain copyright protection is by putting your ideas down in a fixed format. So if, say, you're typing up your research notes for your experiment that you did in the lab, the minute that you write that up into a Word doc, that is in a fixed format, you have copyright for that. You don't need to do anything else. It used to be prior to the 70s and 80s that you had to file with the Copyright Office, and at one point even put sort of a notice of copyright on your item. That's where that classic C symbol we are all familiar with came from. But due to changes in copyright law during sort of the late 70s into the 80s that aligned us more with how copyright law worked with a lot of the rest of the world, that's no longer legally required. The minute that you put it in some kind of fixed format, you just automatically have copyright protections. And you, as such, so once you do that, you can like take someone to court if they violate your copyright. You don't have to register with the Copyright Office to defend your rights. Now, you still can register with the Copyright Office, and in many ways, that can be a little bit easier in defending your rights in court, but it's not required to be able to successfully do that. And when you put, when something enters into copyright in US copyright law at this point, the length of time that is the life of the author plus 70 years. And that happens regardless of whether you retain the rights or give them or sell them to another party. And that is something you can do with copyright. You can transfer your rights to someone else. So that's kind of gives a good overview of like the high levels of copyright. Obviously, within academia, we want to make use of copyrighted works, and largely we're doing that through accessing licenses, asking permissions to do certain things with them. But I think as we're all in academia familiar with the term, there's also the other form of usage of copyrighted materials, which is fair use, which is helpful to touch on. And that's a legal doctrine in copyright law that allows somebody to make limited use of a copyrighted work without having to get permission first. It's in many ways fair use. There's a lot of risk mitigation involved. You're trying to do the minimal amount and use the minimal amount of a material to have the least amount of impact on the original author's work. So when these tend to be considered an adjudicated court, there's these 4 factors that tends to focus on. So the purpose and character of the use, particularly if it's commercial versus like nonprofit educational use, the nature of the work that copyrighted work that's being utilized, and the amount and like how substantial the portion that is related to the whole work. So obviously, using less is almost always safer, but depending on if you're using some of the most important key points, it might get a little dicey. And then also like the effect on the use of your use of the material and how that affects the original's sort of market value or just the value of that original work, and sort of are you harming the original author by the way you're using the copyrighted work. So when you're engaging with fair use, you want to keep an eye on these 4 factors and try to mitigate your risks as much as possible when utilizing things fair use in this way. But obviously, fair use is certainly a good and helpful legal doctrine that we want to make use of in academia. And there's plenty of folks that can help think through that as you make use of copyrighted works in your own scholarship. And one other quick thing I wanted to touch on is just providing a little bit about Drexel's intellectual property policy, which, in case you didn't know, Drexel has an intellectual property policy that defines how particular types of IP are thought about, and ownership is considered for scholarship and work done here at Drexel. We're not going to go over everything in that. You can find it just by doing a search on Drexel's university website. I think we've also got a link at the end of the slides for it, but we're going to just highlight a few points that are of particular potential interest. So when looking at scholarly works, things like your journal articles, your book publications, student work, even course materials faculty create, Drexel is not going to try and claim any copyright on that. The rights, all the copyright for that is retained by you as the creator or author, though Drexel is going to require you to allow them a non-exclusive license to distribute your work. So any of this scholarly work you do through Drexel, they still want to be able to provide access to it. Whereas things that are more commercial work for hire, things that you traditionally see done more within the sort of standard job. So like if you've got a department marketing email campaign going on, all the materials for that is something that Drexel is going to retain the copyright on. So hopefully the difference on that's pretty clear. And this is also here where our brief cameo of patents come back. So by and large, with patents for work done at Drexel using Drexel resources, in most instances, Drexel is going to actually retain the ownership of the patents there. But there might be a little flex. Read over the policy for yourself. Don't just take my word for this. I'm not going to be liable if you don't read it over and violate the policy, but they have it online. You can talk to general counsel if you have more additional questions about how intellectual policy works here. And now I'm going to hand it over to Hannah for the next section on academic publishing.
Yeah. So now I'm going to talk a little bit about copyright and academic publishing, because it does work the same way as the other forms of copyright in that it has to be a fixed work. However, when you're publishing, depending on your contract with the publisher, generally you are transferring your copyright to the publisher. So say you wanted to publish a journal article with a publisher. By publishing with them and reading your contract and signing it, you are generally giving up your rights as the copyright owner to the publisher. So in that case, if you ever wanted to reproduce that work or prepare derivative works from whatever you had published with that publisher, you will need to contact the publisher and ask for permission to do that. However, this is a case-by-case basis depending on the publisher. So it's not a requirement that when you publish something with academic publishers that the rights are all assigned or transferred to the publisher permanently. You can have them be licensed temporarily or on a non-exclusive basis, and it does depend on your contract. So I really want to emphasize that this is not the same for all publishers. Publishers are all different, and their terms and conditions are all different. So you really do need to read your contract fully before you sign and decide if you're going to sign over your copyright. And we'll talk a little bit more about that later. But for now, we're going to talk about open access publishing and what that means. So open access publishing is the free, immediate online availability of learning materials, research, data sets, or creative work to the public. So what does this mean in practice? This means that anybody on the internet, if something is published open access, they can find it and they can read an article or a book chapter in full. They can see those data sets. It doesn't mean that you can use that information. They are still copyrighted, but you can, usually they have a Creative Commons license, like Matt was talking about before, where it'll say, oh, you can, use some of this, usually with the correct attributes, so that you can, expand on that research. So in order to publish open access for free, some publishers, or not for free, in order to publish open access, some publishers require authors to pay article processing charges in order to publish their articles open access. So these article processing charges can range anywhere from $150 to $7,000. I've even seen some as high as $12,000. And so it really depends on the publisher. So why should we publish open access? Next slide. So why should we publish open access? By having your work published open access so that anybody can read it, you're expanding your reach. It's more visible to people outside of your sphere and outside of people who have institutional access to academic libraries. This means that research can be expanded upon. This means that your citation count can grow. And this means that there's going to be kind of a reproducibility of your work. People are going to be able to verify your work. And, you're just going to get more reach. And the transfer of knowledge is always valuable to society. Next, we're going to talk about the different types of open access. So when you talk about open access, there's generally three main ways you can publish open access: gold, green, and hybrid. So gold open access is usually facilitated by the publisher. So this means that the published version of a journal article is usually made open access immediately and permanently, and it will be freely available for anyone with internet access to read or download from the publisher site at the point of publication. Most gold open access journals are only published online. They don't have physical copies, and you do generally have to pay an article processing charge when you are publishing gold open access. The green version of open access utilizes institutional repositories. Our institutional repository at Drexel is Drexel Research Discovery. And so in an institutional repository or digital archive, you can make your preprints or accepted manuscript copies freely available. So you can put in your PDF files so that your research is considered open access. It might not be an published article, but it is your research and it is copyright. Now the third option is hybrid. So some journals and some publishers make some of their content free and open access while having other articles hid behind paywalls. And this is because authors can choose. So if you are going to publish in a hybrid journal, you can choose if you want to pay an article processing charge and make your content open access, or you can choose to not and make it paywalled so that other people cannot read this. And this is all down to the individual researcher's choice. However, Drexel has open access agreements. Next slide. So open access agreements or transformative agreements are agreements that allow, through negotiation with publishers that the library does, allows for researchers at Drexel University to publish open access for free. So depending on the contract, when you find a specific publisher, you can contact the library or look at our open access publishing guide that is linked here and check to see if we have a agreement with them. So currently we have several agreements, including agreements with the Association for Computing Machinery, the American Chemical Society, Elsevier, Cambridge University Press, Company of Biologists, the Institute of Physics, the Royal Society of Chemistry, and Springer Nature. So in any of these publishers, you can publish open access for free or at a discounted rate in any hybrid journals. And so this means that while Drexel pays a little bit of money on top of our subscription fees to access content, that means that any researcher who wants to publish open access can do so for free, just because of a little bit of money on top of our subscription costs. And so more information about participating in these agreements can be found at that LibGuide, which Stacy has put into the chat. But if you have any other questions regarding how these agreements work or participating in them, please feel free to reach out to me. And now we're going to talk a little bit about copyright and AI. So I'm going to pass it back to Matt.
All right. Yeah. So, of course, it's 2025. We can't get away from artificial intelligence at the moment. So we wanted to just talk a little bit about how copyright and academic publishing are both sort of touching on and touched by AI. And particularly with copyright, when we're thinking about that, there's still a lot that's really being figured out and developed right now. The U.S. Copyright Office has put out some really helpful reports this year to think through and understand it. And when we're thinking about this, there's kind of two areas related to copyright and AI that that are really worth digging into. One of which is just what is the copyright status of works or materials generated by AI. And then the other one is how is copyright impacted by training AI models on copyrighted materials. So we're gonna take a look at each of those before then talking about the academic publishing side of AI. So we'll start with what it's sort of the status of copyright status of AI generated materials. And in many ways, this is honestly the easier one. According to the US Copyright Office, they don't really see a need for much in the copyright law to change for this. And a lot of that comes down to this quote that's the first bullet here from their report, that copyright law protects only works of human creation. So as such, copyright doesn't really extend to materials that are purely generated by artificial intelligence, where there's little or at least insufficient amount of sort of human effort and creativity put into it. So simply by creating a prompt, even a moderately complex prompt to generate an essay is often not enough human effort and creativity to actually have that considered to extend copyright over the materials that generates. A sort of example that's given is like it's similar to an author who wants like an image for a book cover. They go to an artist and sort of give them their requirements, what they want for the image, and hire them to do that. The author, while putting a lot of stipulations out, hasn't actually done the creative work of creating that artwork. And so it sort of seemed from a legal perspective that this is similar with AI, except for AI is not human, so it doesn't have copyright. Whereas if at least some relatively small amount of human effort is involved into the work, then copyright does extend. So copyright protects original expression of human authors, even if it includes AI work. So for example, if an artist loads up DALL-E and then puts in a prompt to create an image and then takes that and then reworks it in their own style, and then even puts it back into the AI to put some little nice finishing touches on it, that's enough effort that would be considered protected by copyright. So hopefully that makes it easier to see that in many respects, sort of what is considered enough human contribution when dealing with the sort of AI generated outputs is going to vary a lot and needs to be analyzed on a case by case basis. But I think a helpful rule of thumb for yourself, if you're going to use AI to help you in your work and you want to have copyright over the outputs, is just writing a prompt isn't enough. You need to put some additional work and creativity on top of the outputs of the AI for that. Now, then we got the flip side here of training your AI models on copyrighted works. And this is a little bit more complex. At the very least, it's there's no way one can argue that training AI on copyrighted works isn't impacting copyright. Just by the nature of how AI training works, it is utilizing things that fall under copyright because it has to make a copy of all the data that it's bringing in, whether it's scraping it from a website or getting it ingested through a human into the system. And it has to make copies of that to run through the training, possibly multiple times. And depending on what you think of the kind of outputs, it could be argued that it might even be creating derivative works of those originals. So there's things here that is definitely impacting on copyright law. As such, there seems to be from the reporting from the Copyright Office and some of the various articles Hannah and I have been reading over, there seems to be sort of two camps that seem to be developing on this. On the one side, and which tends to be much more of the AI companies and AI producers, are making an argument that this is fair use. This is not directly just sort of regurgitating the same thing. It's a transformative use. And so that it falls under fair use. On the other side, which tends to see more authors and creators, but again, there's wiggle room in both these camps, that an argument that this is not fair use, this is flagrant mass copyright violation, and that the folks using the AIs either need to stop using their works or contract them and pay them to license the use of their works. And a number of creators argue that this is actually creating direct competition from the sort of outputs. Right now, there are a number of cases that are being adjudicated in the courts. There's very few final rulings that have come out at this point. So there's not a whole lot we can necessarily say here. It's probably not going to be until next year that we start seeing more concrete legal rulings, though we are seeing some groups looking at other ways to kind of work around the legal aspects of this. Some groups that are looking into sort of like creating licensing packages so that somebody who wants to train an AI can just buy sort of a license package for a bunch of works to feed that through their AI systems. And currently, Cloudflare is looking at ways to both gate AI from crawling sites when the site site host doesn't want them to, but also providing a possibility of sort of creating for sites that want to, creating a little surcharge that it can crawl it if it pays the site host for making use of the content. So there's some ways this is being explored. There's honestly not a lot of great suggestions or advice we can provide in this. But if you're training up AI, we just encourage you to be cognizant of this and kind of think about the potential copyright concerns you might be running into down the line, depending on how adjudication falls on this. And I'll hand it over to Hannah to discuss academic publishing in AI.
Yeah. So again, I want to emphasize here that all publishers are different. There is no one right answer to this. So it's important to take a look at whichever publisher you're working with, what's in your contract. So most publishers in the last year, because AI is relatively new, and the use of AI in academic publishing has kind of really blossomed in the last year. And so we're finding that a lot of publishers are restricting the use of generative AI and not allowing the submission of articles that use generative AI. This is because there's an unstable nature in the way generative AI is creating some results. And that has led to mass article retractions, generally because that generative AI is kind of hallucinating sources that do not exist. And so I'm sure that'll improve in the future, but that's currently the situation. However, for some publishers, this is a case-by-case basis. So it can depend on how you're using generative AI, and it can depend on the publisher. So you really do need to read your contract. A lot of publishers have AI statements now. So before you submit your manuscript, you should look through these because they aim to ensure transparency and accountability in the use of AI while also encouraging responsible and ethical practices in academic writing. Publishers don't want you to submit something using generative AI that violates copyright. So next slide. I think it's also important when you're looking at publishers and look at what policies they have regarding their use of AI, not just yours. Because some publishers have different policies on whether they're going to train their AI models on your work. There's a lot of publishers now that use discovery systems that utilize academic or artificial intelligence insights. That means that they're reading your entire article and feeding it into this AI model. So you need to check your own contracts to see if they will use it to train their own AI tools or other AI tools. And some publishers are even using AI tools in the peer review process. So I think there needs to be a little bit more hesitancy to do that, and you need to kind of look into the way your publishers are handling that peer review process, because if they're using AI to do the peer review process, it's possible that it's not really a credible peer review. So it's something that everybody should look into, and you really need to read your contract. In the last year, there have been some big name academic publishers that have, after the fact, sold the works of a lot of academic authors to train things like Microsoft's Copilot and things like that. And authors were only asked after the fact if they wanted to opt in or opt out. And so I think that's something that's important to note, because when you are publishing with some publishers, you are transferring your copyright to them. So they don't necessarily have to ask anymore. So you need to read your contract. However, new things are happening in AI and academic publishing every day. So it's important to read the news about it, to talk to people about it, and to actually contact your publishers and kind of negotiate your own contracts, depending on what you think needs to be done. And our last slide is references from how we got all of this information. This isn't comprehensive in any way. There are more articles out there, and I would really recommend looking at that U.S. Copyright Office report on copyright and AI. So for the rest of the time, I think we'll take any questions anybody has.
Thank you, Hannah and Matt. That was great. Like Hannah said, we can take questions. If you prefer to write them in the chat, I can read them out loud, or feel free to just unmute and get the conversation started. Anybody? Oh,
Yeah.
yes,
Hi.
Catherine.
Hi, everybody. So I'm Catherine. I am Senior Manager for Access Services here at the library. And in a previous role here, I was the Course Reserves librarian. So hearing Matt and Hannah talk about copyright brought back some wonderful memories of me sort of wading through the copyright landscape from a course reserves perspective and fair use. But I am actually curious, and I was curious about AI and archives, right? And whether or not there's been any conversation about taking our own collection and doing anything with AI to either make it discoverable or, I don't know, maybe improve the quality of images or maybe do something similar to what ANS is doing as far as looking at handwriting of old documents and sort of using AI to transcribe them or using any sort of tools to improve accessibility or quality of digitized archival content.
Oh, given that I live in our archives department, I guess I should field that question. Uh, we haven't done a huge amount. I did a little work last year in the last year, just kind of looking at some of the tools, but we haven't delved too deeply. A little bit of the experimentation I've done in trying to just kind of clean up some of our metadata had some interesting initial process with Copilot, but it did not scale well because Copilot can't take large batches of things to work with. So that's a bit of a limitation. I know, and being on the program committee for the Code for Lib library tech conference over a number of years, we've been seeing a lot of people experimenting in this space, though. And particularly handwriting transcription and audio transcription are two areas that we're seeing a lot of experimentation with in AI. And there's definitely some interesting things to explore there. We haven't done a whole lot necessarily with handwriting transcription. We might look at that eventually. We probably would. We might be looking a little bit more at the audio transcription first, because we actually have a collection in Alma Digital, which is our archives digital collection platform of student oral history interviews from the COVID quarantine that have machine-made transcriptions from 5 years ago, which we think the text probably improved a little bit. So there's a good chance we might look at exploring on improving those transcriptions sometime in the next year. But that requires some playing around with it. But we're certainly open to it, but we also want to see in ways in which the tech develops. And there's certainly concerns of with like anytime we would run things through a machine, an AI, like what's happening to that data? Because we don't want to just hand away data and sort of information that we are stewards of to a large open model. So we want to be good stewards of the copyright and sort of materials under our care. And so we're being probably a little bit more conservative than some parts of the university about this, but there's still a lot that needs to be figured out and developed. And it would be interesting to see the way these tools change over time.
Thanks. And then I just want to make one final comment, and that is for a really fun and interesting example of how copyright, at least in the US, only covers human-made creative works, I will draw your attention to the monkey selfie copyright dispute from like maybe 10 or so years ago, where a monkey took a picture and there was this huge copyright battle over who owned the copyright of the monkey selfie. So not machine related, but definitely a good, fun example of copyright.
Absolutely. Thanks, Catherine. One of our attendees asked if we can share the PowerPoint slides later on. Would that be okay, Matt and Hannah? Great, then we absolutely can. We'll send the slides along with the recording of the session, so you can watch this over and over again. We'll also post it on the library's YouTube channel, so you can always find it there when we're done. Let's see. Any other questions? Please, again, feel free to unmute or type in chat. Questions about AI and copyright or just open access and some of our APC agreements. If there's any questions, we'll be happy. All right. Oh, it looks like we have one. Jay, you want to go ahead and unmute and ask away?
Sure. Okay. My question is, by the way, it was a great presentation. Suppose I'm using AI and asking, writing a prompt, and it gives me some ideas for a story. And if I write that story using the content generated from AI, who owns the copyright for that?
So
I think if you're writing this story, like if it's not exactly what AI has written and you are building upon that a lot more, I think you own the copyright. Is that correct, Matt?
yeah, so if you put in the prompt to the AI and just copy and paste what it output without doing any modifications, no one owns that copyright. But if you use that as a base and then change it up, make modifications, build upon that, then you've added your own creative work to it. And even though the seed came from the AI, you actually own the copyright.
Okay, good. Thank you. Because that is what I was concerned about. Many times what happens is that people are asking questions, and based upon how you prompt, you give some certain good response. And that could generate a different idea. And the idea came because of AI's interaction with you. And as you mentioned, then it is not because AI will not get copyright for that, because it's, even though idea was not generated by AI, it's an, I guess, question, who has generated that idea?
Can you repeat the question?
Who generated the idea? Is it me or AI?
I think if you're prompting it,
Yeah, I'm prompting it. I'm getting responses.
I think that's a hard line. What do you think, Matt?
Right.
I think that goes to this is figured out on a case by case basis.
Right.
From copyright's perspective, it doesn't necessarily care if you or AI came up with the original idea, but if once you start putting your own creative work into the output, then like you've done creative work, that's yours now.
Good.
Great question. Thanks, Jay. Anybody else have a question they want to ask? Happy to ask. If not, you can always reach out to us later and we can always answer questions through email as well.
Thank you.
Great. All right. Then hearing nothing, session adjourned. But please, if you do have something, just type it in chat or you can email me and I can pass it on to Hannah and Matt if you don't have their contact information. Great. Thank you all again for joining us. We appreciate it. And we look forward to seeing you at a future event.